You can have the law on your side but still lose the case. That's how serious it is. Many Kenyans, because of ignorance, make some very fatal mistakes to their case and ruin their chances just because they are not aware. So if you've been confused or you're sued and you don't know how to respond now that you've been sued, keep watching. My name is Gloria Nafula. I am an advocate of the High Court. I practice law and I've been practicing for the past few years now. And I specialize in family law such as divorce, custody matters, employment matters, and land matters as well. Now, so here are the three fatal mistakes Kenyans make when they're sued. Number one is lack of evidence, okay? You are a certified yapper, meaning you're going to court with claims you cannot prove and you expect the law to believe you without any evidence. You don't keep receipts, you don't take screenshots, you don't keep records, and now you want the court to believe you on your word alone. Unfortunately for you, that's not how it operates. The law is that he who alleges must prove. This is based on a Latin maxim, it's Latin called onus operandi, okay? Just in summary, is the burden of proof. Usually this burden, like a weight you're carrying, to prove something is on he who alleges. Imagine if we were telling people who we accuse to prove that our accusations are wrong. That would be unfair, right? So the law puts the burden of proving what you're saying to the person who's alleging it, right? Because I said so isn't something that the court is going to accept. They want you to bring receipts. And the law on this is clear in the Evidence Act, Section 107. For those who are interested, it says that whoever desires, any court desires, you want the court to do something for you, okay? And it's dependent on the existence of a fact which he asserts, you must prove that those facts exist. What does this look like in a case? It looks like saying that somebody, for example, you're doing a custody case and you're saying the person is denying you access to the kids. It's attaching those screenshots where you texted them asking them to see the child and they refused. It's bringing them to court, telling the judge this person has refused, and giving sworn testimony that this person has actually refused to give me the child. So it's bringing evidence for every single claim you have. So you must be in this habit of having written evidence, writing things down, taking screenshots, following up through emails. That will help your case immensely. Now, because Kenya is an adversarial country, which means, okay, the Court of Superior Record, which is the High Court, Court of Appeal, Supreme Court, these courts' decisions bind on the lower courts, such as the Magistrates Court. That is the case of Kingara and another versus Jongi and another. In this case, it's a land case. You know those the land where you see, there's a meme going around, where you see the land that your uncles have been fighting about and it's in the middle of nowhere and you wonder why they've been fighting for the past few years. So in this case, it was a similar case where this person was saying that this is ancestral land. This person was holding land in trust for the family because when the person died, he had transferred that land to his son, and his son was now the title holder of that land. But these family members, we'll call them Aunt Margaret and Brother John, were like, oh no, this is our land. This is land that has been in the family. Fair enough. What did the court say? Prove it. Because on his side, on the child of the deceased, he said he had a title. A title is evidence of ownership. So it's upon you to prove that that title is fraudulent or is under, what do you call it? That title is under a trust, right? That the land was a trust. It was held in trust for other people. You prove it because you're the one who's alleging. On his part, he has his evidence. Unfortunately for them, they were not able to prove it. They were saying, oh no, the documents got burnt in a fire, and the court said, prove it. They couldn't prove it. And so they lost the case. The court decided. Uncle Daniel, who was the person who had originally owned the land, left the property to his son while he was still alive. So succession couldn't be brought into this. And it was fair for Francis to own it, right? Those two people who are Aunt Margaret and Brother John were not able to show papers or good evidence proving that they had paid for the land, or there was even an agreement that that land was ancestral land. Of course, they were aggrieved and appealed to a higher court. But the higher court, which is the Court of Appeal, agreed with the first judge, and the family did not show believable evidence that the land was meant for the whole family. So this whole case, the reason why those two people lost was simply because they didn't have enough evidence. Witnesses can also count as evidence. If you have people who saw the thing happen, call them in as your witnesses. Documentary evidence, things like that to prove your case. Your case needs to be coherent and believable. The second mistake we'll talk about that Kenyans do a lot. I've seen this so many times that it kind of irritates me a little bit, because we've lost some cases just because this person did not put in their due diligence, right, and respond. So it's not responding when you've been served with the case. It's like that meme where your house is burning and you're like, this is fine, I didn't put my signature on the court document, so it's fine, I wasn't served. Or you're like, just because, you know, I've been served by WhatsApp, that is not adequate service. Unfortunately for you, under Order 522, these WhatsApp, email, all that stuff is adequate service as long as they prove it's your number, as long as they detail the process. In fact, if you respond to that WhatsApp message, we just need to attach it to an affidavit of service and say that we served you, you just refused to show up. So what does it mean when you receive court documents and you don't respond to it? It means that the court goes on without you. The case will go on without you. And the worst part is, your silence means I accept the charges against me. I accept the claims against me. That's exactly what it means. Silence is not denial. It's accepting. It's acceptance. It's admission. They can make all sorts of claims, but because you weren't there to defend yourself, you've admitted it. So this concept is default judgment, okay? It's like if you don't respond to a court summons in Kenya, the court can enter default judgment against you, which means a judgment in default. You have not showed up, so an automatic judgment is entered against you. And the consequences of this is you have, maybe it's money, now you have a judgment debt. You have money you need to pay, or you can be arrested, or your property can be seized by auctioneers. You're on the road driving, unachoto kwa barabara, they've taken your car, they've sold it. What are you going to do? And now you're scrambling, you know? The law, this is what the law says about default judgment. This is under Order 10, Rule 4 of the Civil Procedure Rules, okay? Where the plaintiff makes a liquidated demand, which means you're asking for money, and the defendant, who have been sued, you refuse to show up on that day, and we show that we served you, judgment against the defendant or defendants for any sum not exceeding the liquidated amount together with interest thereon from filing of the suit can be entered against you. And that's exactly what will happen. In fact, the easiest case for us lawyers is when the defendant refuses to show up. We go quickly and we file that form 13, asking the court to enter default judgment against this person for failing to enter appearance. Now, the law part 2 is interlocutory judgment. Rule 6 of that is now, for example, you're not asking for money. You want maybe land, or you want like a declaration or something punitive, something to punish that other person. That's what you're seeking in your application. Then the court will look through it and enter interlocutory judgment, which means that then we go to formal proof. You go and show your evidence to the court without that person, and the court goes through it and decides what it's going to give you, right? For example, again, accident cases where they need to quantify how much the liability is. You'll make your submissions and the court will make a judgment. But either way, it's way easier than if that person had responded. The simple act of responding can save you so much trouble. You can get arrested for not responding technically, okay? If we execute a judgment via arrest to civil jail. A lot of people don't know this, but civil jail exists. I can get you thrown into jail for a civil matter if I apply for it, okay? So the case law is this. In this case, it was Kihara versus Madhage, right? And there was a man named Kihara who had a problem. And the court made a decision without telling him. He says that the court made a decision without telling him. which is now the default judgment, because he was served and he didn't show up, so the court went on without him. And so he asked a higher court. So now when the result came out, he appealed, which is to a higher court, to change the decision and let him give his side of the story. Of course, the court went through everything and said, nope, we are not changing the first decision. Why? Because you were served properly and you never responded, and default judgment exists. So this is why he failed in his appeal. This is why the court didn't listen to him, okay? Because the cornerstone of his case was that he wasn't served. But remember, these people had put an affidavit of service. That is an affidavit of the person who served you the document saying how he served you, right? And that affidavit, it detailed how he served him, which was in person, and where they were, it was very detailed, right? And then the appellant, on his part, didn't choose to cross-examine the process server, the person who served him. Usually, sometimes when you're challenging service, you can choose to call the process server and cross-examine him on how he served those documents. And then, so if an affidavit of service is unchallenged, to the court, if there's an affidavit of service, it means service was proper. When you say prima facie, you say at the face value. We don't need to think so much unless you're challenging very specific things. The court will assume that it was properly served just because there's an affidavit of service. So next time you're served with court document, go to your nearest lawyer. On our part, we offer consultations. It's a link click away, and you schedule the consultation as soon as possible, or WhatsApp that number, because these things are serious. One wrong move and you're messed up the whole case, okay? And then the third mistake you see over and over again is simply getting overly emotional and making mistakes in the case. For example, you've been served with a divorce matter and you also want a divorce, but the fact that this person has served you with that divorce papers, you immediately see red and think about revenge and how you're gonna, make this person pay. Unfortunately for you, if you were a bit more sober, you'd realize that for divorce, which is contrary to the point I've just said, for divorce, it's the only matter where I'd say you don't always have to respond. If you want a divorce to go faster, maybe you've been served with the divorce papers, then even if you don't respond, then the court will just proceed as it's undefended and grant the divorce that much faster. So depending on what has been put in the petition for divorce, we can choose not to defend it. Or we file a divorce and that person that has defended it, maybe they're in another country, maybe they don't care. Even better, the divorce will go faster, right? So we can get the divorce faster. Sometimes you do need to defend the divorce. Maybe they're making challenges. Maybe they're asking for things like dowry. Maybe they're making claims that are not going now into matrimonial property. Definitely we have to respond to that. But if it's just silly accusations that have no basis, oh, you deserted, oh, whatever, the point is you don't have to respond. But go through them and go to a lawyer who will advise you accordingly based off of what is in the case. So for consultations, if you're interested in consultations, click the link in the description. If you want a divorce, click the link in the description to immediately start the divorce process. Because court has moved on to virtual court and we move fast these days. No time for dilly-dallying, right? Because the law favors the speedy. You'll see that a lot. And then if you have any queries, there's a WhatsApp number there. You can WhatsApp us and you will get our response. If you want to call, you can do a consultation call, which is payable as well. Thank you. Oh, and the consultation call costs 2,500. So if you're interested in that, WhatsApp that number or click the link in the description to set up a consultation. See you in the next one. I hope you enjoyed the video.